I'm Eric. This is Steve and Scott, and we do a lot of defamation work, guys. There's no doubt about it. And today, rather than talk about a specific case, I want to talk about defamation laws and how they may be strengthened or weakened in theory in the next year or two. And one of the reasons why I want to talk about this, I don't want to go down a political rabbit hole, but look, we just had an election, and our next president has filed a lot of defamation lawsuits, no doubt about it. And I think, Scott, you even said at some rallies, he's talked about strengthening defamation law. So, this week, let's talk about what that might look like, because I would say probably 75% of our cases we're plaintiffs. We represent people who want defamation laws to be strengthened. Yeah. So let's talk about some of the barriers, because it's tough to be a plaintiff in a defamation case. There's a lot of defenses, and we live in a country with probably more defenses than any others. We've got the First Amendment. But I want to start off by talking about something we talk about a lot, and it always comes up, and it's called the Section 230 of the Communications Decency Act. And just about every day I get calls from various business people and companies who want to sue Google. They want to sue Ripoff Report. They want to sue Glassdoor. You name it. And I tell them the same damn thing. So you can't do it. Well, why? Because there's this law out there that provides these companies with immunity for the defamatory statements made by their posters. So the first, I guess, idea to explore, or way that defamation laws could be strengthened, would be through some sort of legislation that would alter CDA 230. What do you guys think?
Yeah, that seems like it'd be the clearest and simplest way for the kind of cases we work on, online defamation cases, to expand the remedies for somebody that's been defamed online. You provide some limitations on the Section 230 defense. You make it harder to qualify. I don't know, one scheme might even be making it more like DMCA kind of immunity that we have for copyright claims online, where you have to register your website with the Central Clearing Bureau to receive notices of whatever the wrongful activity is, and the takedown and put back period. There could be just a wholesale removal of it, although that might be kind of crippling to any kind of secondary user source at all. It might kill off YouTube or Facebook or any of the giant websites out there. One thing to note, though, right now, there's another reason that people might have to amend CDA 230 going on. Recently, the California and Texas state attorney generals filed criminal charges against the owners of Backpage.com for postings on Backpage.com related to sex slave trafficking, trying to hold them accountable for Backpage running those kinds of ads and profiting off of it. And in the tentative order that was recently issued in that case, the judge approved a dismissal of the claims, saying Congress has spoken here, it's not for the courts to change this.
That's very interesting. Now, Scott, so one change could be that a business person could sue Glassdoor, for example, and Glassdoor would be liable for defamatory content, not just the poster. But currently, in California, it is the law, according to a case called Hassel v. Bird, that if you get a judgment that a Glassdoor, that a Yelp would have to comply with a permanent injunction. So even though they might not even be on the hook for money, and that case is with the California Supreme Court now, things are starting to change here in California with requiring the removal of the content, which is what that permanent injunction typically does. So that might alter things a little bit.
Yeah, it may. One thing about that case is that it deals with a situation where something is adjudged to be liable. One thing in this country that cannot be changed or can't be practically be changed is the First Amendment, and the First Amendment protects alleged defamatory content to a great degree, especially when something has not already been found by a court of law to be defamatory. If something is defamatory, that's not covered by the First Amendment, but until that finding is made, there's the rule against prior restraints, which is protected by the First Amendment. It's very difficult for a court to say, you can't say this thing in the future. And so there, it was just an injunction, it wasn't monetary damages, and it was there was already a finding of defamation by the court. And granted, it was a default judgment, but still it was a finding on the merits after a default. And so that is a difference, and that actually might be a way you could make the libel laws more First Amendment friendly. Would actually be to abrogate Hassel v. Bird.
Let's talk about something else that you often encounter as a plaintiff, which makes it tougher to prevail on defamation, and that's a state law issue that we often encounter, and that's an anti-SLAPP statute. So, Steve, why don't you tell us real briefly what anti-SLAPP laws are and how they can be strong, how they can be weak, and where they tend to be strong and where they tend to be weak, and some of the consequences of that. And that would be a fix at the state level. And then also, this is going to be a pretty long-winded question to you, there's a movement afoot to, instead of having it at the state level, have one federal anti-SLAPP law.
Right, so an anti-SLAPP law is a protection for people that are exercising some sort of First Amendment right, typically. It may cover everything, including protected speech about issues of public interest, statements to court, statements to police officers, statements to your legislative bodies, those kind of communications, protests.
And they tend to be strongest, I'll just interject here, they tend to be strongest west of the Rocky Mountains, especially right here in California, which kind of sets the stage and informs these other states.
Right.
And in the Northeast, I think there's some pretty powerful ones.
Right, and then there are weaker versions that instead of protecting all speech and all assembly activities, would protect only statements made directly to a legislative body, like the law, I believe in Utah, is limited that way, that its anti-SLAPP law is only protecting statements that are made directly to a legislative body.
Florida is another state that's limited in a similar fashion.
Right.
So,
so the way these protections work is if someone is sued for one of these kinds of activities, at the very beginning of the case, they can put the plaintiff to a test to say, do you have enough evidence to make these claims viable? Not will you win at the end, but is there enough evidence here to make them viable? And the thought is supposed to be it would deter people from bringing not really good lawsuits against people that can't afford to defend them, and deterring the speech that they don't like. For example, the sort of textbook example would be protesters outside of a nuclear power plant are using their right to freedom of assembly, but the people that don't like that bring a lawsuit against them on fairly bogus charges, but the cost of defense is so high, the people that are protesting give up the protest and stop.
So one thing that could happen, Scott, instead of having this hodgepodge, which encourages people like us to pick and choose forums, they call it forum shopping. Why would we file in California with a strong anti-SLAPP statute if we have another available venue open in Florida? Would be a perfectly fine place to file a lawsuit if you could. So, Scott, there could be a federal anti-SLAPP law, and it could be stronger or weaker. And so why don't you talk about how that could influence, strengthen, or weaken defamation laws?
Yeah, if there were a federal anti-SLAPP statute that would deter people from bringing defamation lawsuits. It's, you know, theoretically that's what we're supposed to do in California, and it also you have more robust appellate rights too in a slap situation. So that's one way it could be. And right now, for instance, in the Ninth Circuit, they have, in the federal courts in the Ninth Circuit that are dealing with California cases, California law, they have to apply the anti-slap statute even though these seemingly don't really want to, but they have to. So that would be one way to make it tougher to bring a case. It wouldn't affect the substantive First Amendment rights, but it would deter cases from being brought in the outset.
Okay, I think the final point that I'd like to discuss is it's often very, very hard to prove damages in defamation cases, and so I'll close on this. Some states have what we call defamation per se, which means you don't have to prove actual damages, you can get general damages. So we could see various states, California has defamation per se. I don't know how many states offhand do, but you could see more states enacting defamation per se statutes. I'm getting the wrap it up sign, so that's it for this edition of the Raines-Feldman Cyber Liability Update. We'll see you next time.